welcome everybody to the Mental Health Court Petitions and Assisted Outpatient Treatment with Judge Milton Mack. Assisted outpatient treatment is also called AOT, and you will hear this reference throughout today's presentation. So if you don't know what that is what we're referring to. Lots of acronyms in this work. My name is Mary Ann Huff. I'm the president and CEO of the Mental Health Association in Michigan. And we are really pleased to be co-hosting this webinar with NAMI Grand Traverse. And so with us from NAMI Grand Traverse is Kate Dahlstrom. And we want to welcome Kate. We've partnered with Grand Traverse NAMI to put this together. It's a very important issue that we wanted to make sure that we are talking about it. For the next hour, we're going to take a look at the facts, successes, and challenges presented on AOT and a system that waits for crises to act, which results in treatment delays, and examine these potential harms. Also, this deep dive will explain how standards are interpreted, orders are enforced, and opportunities for diversion out of the criminal justice system that present themselves. So with that, I'm going to go ahead and introduce the Honorable Milton Mack Jr. who is with us today. Judge Mack is State Court Administrator Emeritus in Michigan. He served as a State Court Administrator from 2015 to 2020. He previously served as a judge for the Wayne County Probate Court from 1990 to 2015, and as Chief Judge from 1998 to 2015. He served as the co-chair of the National Initiative Advisory Committee in 2019-2020, which has transitioned to the National Judicial Task Force to examine state courts' response to mental illness, where he now serves on the Civil Probate and Families Work Group and is chair of the Civil Intervention and Processes Work Group. Judge Mack currently serves as chair of the Governor's Mental Health Diversion Council and is author of the Conference of State Court Administrators 2016 to 2017 policy paper, Decriminalization of Mental Illness, Fixing a Broken System. He also wrote Involuntary Treatment for the 21st Century, published in the Quinnipiac Probate Law Journal in 2008. He's received numerous awards for his excellence in service. We are really grateful that he's made time for us today, and do want to add that he just joined the board of directors of the Mental Health Association of Michigan. We are very excited about that. So without further ado, I am going to turn this over to Judge Mack. Thank you.
Well, thank you, Mary Ann. Let me share my screen here. And all right, so I'm going to talk to you today about Michigan's mental health system and how we can stop the merry-go-round or the endless cycling of people through the system without benefit, I guess. But I'm going to cover several points. Number one, I'm going to cover the new standard for ordering involuntary treatment. I'm going to talk about the need for hospitals and emergency departments to recognize that standard and to comply with the deferment processes in the mental health code. I'm going to talk about the ability to seek assisted outpatient treatment without hospitalization and how the AOT process should work. And finally, I'll talk about the need for communities to work together and understand their respective roles. Let me see. All right, here we go. So this is going to be about the mental health code revisions from 2016 and 18 and assisted outpatient treatment. So I was a member of the Mental Health Commission back in 2004, and we made some key findings. Number one, the mental health code was an inpatient model in an outpatient world, meaning that it was oriented towards preventing unnecessary hospitalization, not oriented towards promoting treatment on an outpatient basis, despite the fact that the vast majority of mental health treatment today is delivered on an outpatient basis. And the system waited for crisis to act, which results in delays in treatment, and we found that delay was harmful. Among the harms are a loss of resiliency from these episodes, incarceration, well known, poverty, homelessness, isolation, poor health. You may end up with the appointment of a guardian if you're lost too much capacity. There's also an increased risk of dementia, drug abuse, and suicide. Yet we know that with early intervention, much of this risk can be reduced. Now, the criminal justice system has stepped in to help out. And the problem-solving courts we have there are helpful, but they're too limited and they're too late. We have over 200 problem-solving courts in Michigan. They served 7,000 people last year, but rejected 3,800. And if you look at what's going on nationwide, emergency department patient volume nationwide between 2006 and 2014 increased 15%, but psychiatric patient volume increased 44%. So the civil justice system is really the best place to start if you want to defer people or divert people from the criminal justice system. This number is kind of startling to me when I first heard it, but MDHHS reports that for at least the last 3 years, the number one reason for emergency room visits in Michigan was psychiatric care, not COVID. Nearly 166,000 visits in 2020. Part of the problem is, with those 166,000 emergency room visits, only resulted in 18,000 petitions for mental health treatment. Now, these are persons who were screened. They had 2 certifications that they needed hospitalization. They were hospitalized, and a petition was filed and a trial set in 7 days. But nearly 60% of these petitions were dismissed, withdrawn, or deferred before the hearing date. No order was entered. Were any of these people connected to outpatient treatment? We'll never know. If you look at Wayne County as a good example, their CMH serves about 38,000 adults with serious mental illness. Over the last 5 years, 16,000 petitions for 9,000 individuals. And again, about 60% of the petitions did not make it to the courthouse. What happened to them? Well, if you look a little deeper, 600 of those 9,000 people, that's less than 1% of the person's petition, they accounted for 36% of all petitions filed. And I would suggest that might be the common experience across the state. So what you have are emergency department visits, short hospital stays. Without connecting to the community, it accomplishes little, it wastes resources, and just makes the process a revolving door. The good news is we now have the opportunity to do better with the community working together. So Michigan's new processes, number one, they permit earlier intervention. You don't have to wait for crisis now. The mental health code no longer relies on threat of imminent harm and danger to self or others. It's been deleted. It's not in the code anymore. The new focus is on risk of harm, and the immediacy of the risk of harm governs whether it's hospitalization or outpatient treatment that's required. So again, dangerousness or threat of immediate harm is not required. So the first part of the statute speaks to someone with a mental illness with a reasonable expectation that they're going to seriously physically injure themselves or others in the near future. And they've engaged in an act that supports that expectation. But the Court of Appeals held that that act could be something that happened 2 years ago or even longer. And that means that in the particular case, Hedera Staffa case, the doctor testified that at the time of the hearing in this matter, the respondent understood he had a mental illness and it required medication, and he was compliant in the hospital. But because of his behavior in the community, he could be expected not to be compliant, and therefore he would expose himself to danger, and concluded that past history was more predictive of future behavior than his current statements. And the Court of Appeals upheld that an act from 2 years previously could be used as the act. You don't have to have an act right now to support that provision. And this is an interesting case. New code looks more towards a person's capacity to make informed decisions. And in this case, the Court of Appeals held that the testimony from a doctor that untreated schizophrenia increased the risk of dementia, drug abuse, suicide, and further decompensation, including delusions and paranoia, was sufficient to order involuntary treatment. And what's most interesting is the doctor testified that the respondent was not at risk of harm at the hearing, but he was at risk of harm due to lack of insight and history of decompensation. The doctor testified that he did not understand his need for treatment, he could be expected to stop treatment in 3 to 6 months and decompensate and be at risk of harm, drug abuse, and so forth. So again, we're looking at a person's capacity, and we're looking at the risk of harm. Really, for the 401c standard, which is the new one, and I think that's the one that can be used by families in particular, these are the questions you have to ask. Does the individual have a mental illness? Is the person's judgment impaired? Does that impairment cause a lack of understanding of need for treatment? And is the person unwilling to engage in treatment? If you answer yes to those questions, then you go on to, is that treatment necessary in order to prevent a relapse or harmful deterioration? If that answer is yes, then the question is, will that present a substantial risk of significant physical or mental harm to the person or others? In the Spalding case, the judge concluded, and the Court of Appeals agreed, that there was a substantial risk of significant physical and mental harm to the individual because of their lack of understanding of their need for treatment. So this scenario creates the opportunity for early intervention. You don't have to wait for a crisis. So we think about the old standard. That's the one I'm sure you're all familiar with. There's an immediate risk of harm to self or others. Well, this is the new standard. There's a substantial risk of harm due to impaired judgment. However, in order for this to work, everyone needs to recognize this new standard. And the standard does not relate to ordering hospitalization. If you look at the petition carefully, it says petition for mental health treatment, not hospitalization. Hospitalization is something you can request. But again, it's the severity of the illness and the immediacy of the risk of harm that dictates whether hospitalization or AOT is more appropriate. Not unlike all other diseases, frankly. So here's a particular problem. These are deferments, and these are a huge missed opportunity. Of the 18,000 petitions filed in Michigan in 2020, 1/3, 6,000, were resolved by deferment. And so my question is, were these individuals connected to treatment? Well, how's the deferment process intended to work? It's actually a good process if you employ it. So the hospital is required to notify the individual once a person is hospitalized and certified and the petition is filed with the court. A deferment conference is scheduled in 3 days at the hospital to discuss the treatment plan. And the hospital is to notify the individual, legal counsel for the individual, a treatment team member from the hospital, and a person from the community mental health services program. The reason for that is to identify who is going to be providing treatment in the community. Big problem here. Hospitals are not giving notice to the community treatment provider. So why is that important? Well, because at the meeting, the proposed plan of treatment is presented, as well as the proposed plan of treatment in the community of either assisted outpatient treatment or a combination. And then if the individual has agreed to treatment, then the hospital is required to release the individual from the hospital to the outpatient treatment provider. Now, if you don't notify the outpatient treatment provider of the petition and the deferment conference, they're not going to know that they have a job to do. And the reason that's important is because during the deferral period, if the individual refuses treatment, then the court's notified and a hearing can be convened, and if necessary, order the individual taken to the hospital. But if you're the community treatment provider and no one has told you about this patient, then we'll never know if the person applied with treatment or not. We do know that in most counties, hospitals are not giving notice of the deferment. Now, I can say that Wayne County is now. And since the first of the year, they've got about 800 people ordered into assisted outpatient treatment. And there's been participation in the deferment conference, but this has to be done. So why is this important? Well, because if you can connect people to treatment in the community, then you can get a better outcome. We know that AOT is an evidence-based tool that promotes recovery, reduces harmful behavior, lowers hospitalization and emergency room use, as well as reducing costs. We know that it results in substantially higher levels of personal engagement and treatment. Patients are no more likely to feel coerced with AOT than being there on a voluntary AOT. In fact, the data shows that the best predictor of compliance or satisfaction with a treatment plan was the patient's perception of being treated with dignity and respect by mental health professionals. Because you see, you can get AOT at a deferral. So Genesee County, which probably leads the state in this area, has a number of people who are on AOT, but as in essence through a deferment process. And they have those who are there on an order process. But it's how they're treated that really matters. We now have a mental health code that's an outpatient model in an outpatient world. We can intervene before crisis, and the court can order assisted outpatient treatment. There's no special provision to order AOT. You don't need a history of hospitalization or incarceration. It's not required. The only question is the person a person who requires treatment? If they require treatment, then you can order AOT. Review hearings are not required under Michigan law, and I don't recommend it. Review hearings are something you see in the problem-solving courts, which is a criminal process. And I think it's important to keep this a civil process. In the event of non-compliance, you can have a hearing or a status conference. And I can tell you that in Genesee County, they have nearly 400 people on AOT right now. And 90% of the individuals are compliant with the treatment. For the 10% who are not, about half of them, they're able to eventually coax into compliance. And the other half, they need to see the judge. And if you think about that, before AOT, these 400 individuals would not have been connected to treatment in the community. They would have been released from the hospital and they'd be back in the hospital. The experience in Genesee County is 60 to 70% reduction in hospitalization because people are on AOT and compliant with treatment. So if the court does find that someone requires treatment, then the court can order AOT for up to 180 days through the community mental health services provider. If the court does order AOT only, then the court does have to consider the preferences and experiences of the individual. And if it conflicts with an advance directive, then the court has to appoint an independent psychiatrist to review the plan. The number of things the court can order are pretty broad. Case management services, for example, medication, including injectables. What I find interesting is the court can order alcohol and substance use disorder treatment or testing. The court can order any other services that are prescribed, such as peer support. So it's a wide range of things, and like supervised living. We know housing is a big problem. So the court can order all these things, but that's really not the end of it. Because once the court enters the order for treatment, then a psychiatrist is required to supervise the preparation and implementation of the AOT plan. And just one of the glitches in this whole process, when this law was passed, the court rule did not require that the order for AOT be served on CMH. So they weren't. And so these were orders to nowhere. Well, the court rule has been changed, and now the orders are required to be served on CMH. And we are seeing some compliance with this particular statute. We know that in most counties, we do not have compliance with this part of the statute, but this is the way the court knows that the plan has been implemented and it's underway. The plan itself has to be completed within 30 days after entry of the court's order for AOT, and then forwarded to the court within 3 days after that. And so the way it works is the court enters an order authorizing a number of items, and the psychiatrist has to prepare and implement the actual plan, which might not include everything the judge authorized and may include things the judge did not. So in the event of non-compliance, the psychiatrist have to go in front of the judge or actually a representative from the treatment team. And if it's something that had not been previously ordered, the court could order it or otherwise modify the plan. So the plans are designed to be fluid based on the needs of the patient as applied by the psychiatrist. So the Mental Health Code now provides two pathways for anyone to petition to obtain court-ordered treatment. And when I say anyone, I mean any person over the age of 18 can file a petition for mental health treatment or for assisted outpatient treatment only. The traditional method is where petitions originate from the hospitals, and in those cases, the hospitals typically ask for hospitalization or combined ordered hospitalization and AOT. But the second, which is new, is AOT only. And this bypasses the hospital entirely. And this is something unique to Michigan, which has not been employed very much, but is beginning. So if you're only seeking outpatient treatment, then the petition can be filed with the court without a certification by a physician. This is the form is PCM 201. You just check on the back of the paper that is AOT only. And so you get a bare petition filed with the court without a certification. And then you need to get an examination by a psychiatrist. If the person refused to be examined, then the court can order an examination and police can transport the person to a crisis center for an evaluation. The challenge with AOT only petitions is the need for a psychiatrist to testify. The process of changing the statute has been slow. For some reason, the law before 2016 made it more difficult to order outpatient treatment than hospitalization. I would think that it should have been the other way around. So this is a part of the law that we are looking to modify. Community treatment providers who have access to psychiatrists, they can secure treatment for their clients without waiting for a crisis. So, for example, in Wayne County, a number of the persons on AOT have community treatment providers. And those providers can tell when someone is starting to go off the rails, and then they can proceed and file a petition and get the person back on board again. In Genesee County, when they have someone in that situation, they can kind of recognize that things are starting to go south. And if things aren't going well, then they can file that petition for AOT only. Mediation is another tool that is brand new in Michigan. It hasn't been used very much, but it could be used before filing a petition for AOT. It could be used once a petition for AOT is filed, because the hearing is not for 28 days. And the hearing itself could be adjourned since the person is not in custody. It permits earlier intervention while the individual's cognition is not as impaired. So, for example, in Wayne County, if a person files a petition for AOT only, then the mediation tribunal is notified of the matter immediately, and they notify the attorney appointed for the individual, who then requests mediation. And so far, we've had 5 cases go to mediation. In 3 of them, the respondent agreed to a treatment plan. And that's actually a far better alternative, because in mediation, if you have ownership of your treatment plan, the likelihood that you'll be engaged and compliant is much better than if I, as a judge, simply order something. So the thing that really matters, though, is it does take a community to make the system work. It takes the courts, law enforcement, families, community treatment providers, emergency departments, hospitals, mental health advocates. It takes everyone working together to make this work. And if they don't work together, we're going to end up with the same problem we have now. So there has to be connection here. So let me ask, there has to be connectivity through this whole process. If hospitals and emergency departments simply treat and release without connection, that's a problem. So think of the courts. The courts need to convene the stakeholders in the community. Wayne County has done that big time. Genesee County has done it through the CMH, but someone's got to take a leadership position in the county and convene the stakeholders. And the one thing judges can do is convene stakeholders. We don't necessarily have the answers to much of anything, but we do know who does, and we do know how to get them to come to a meeting. So in Wayne County, they convened the stakeholders, they had regular meetings. I would suggest that all mental health hearings should be held remotely. I would suggest, for example, that you need to track these AOT orders. And then if there's non-compliance with treatment, set a status conference. And rather than file a treatment plan with the court, file a summary of the treatment plan. I think that would be sufficient. But the court really has to look carefully at this. And I would even hear discharges. Normally we get a case is called and we're told patient's been discharged. Well, if the petition asks for hospitalization and AOT, then AOT is still alive and that hearing needs to go forward. So I think the courts need to be more aggressive in terms of addressing the 60% that have not been getting to the courthouse after the file. Law enforcement. You know, police are involved in the pathway of care for almost a third of people with mental illness in the United States. It's not true for heart disease. Law enforcement needs crisis intervention training. We need to transport people to crisis centers instead of hospitals. And they need to use new standard for intervention as well. They should consider filing AOT only petitions to bypass the hospital or simply advise families of that option. And you can consider co-responder models. Now, this is not an exhaustive list of things, but these are sample things of what can be done by law enforcement and others. The community treatment providers. I would consider mediation at the first sign of non-adherence. And I file for AOT if you have continued non-adherence. Without that, just make sure you've got a psychiatrist who's able to testify. But the community treatment provider has to have a relationship with referring hospitals. You have to have that connection too, so that the hospital knows where the person needs to go. And then the emergency departments. Emergency departments are the primary gatekeeper next to law enforcement. And you have to apply the proper standard for persons who enter the ED. If they meet the standard for treatment, but the risk of harm does not require hospitalization, then connect these individuals with a community treatment provider. And the other thing we need, and we're developing that in Wayne County, is you need a memorandum of understanding with CMH and your certified community behavioral health centers to assure that persons in need of treatment are connected to an outpatient treatment provider. We all know the stories of persons who go to the hospital for treatment. Well, I can tell you a short story of in one of our suburbs in Wayne County, the police chief said to me, we had a call about a woman who was laying naked in the road. She'd been running through the neighborhood naked the day before. Law enforcement went out there. She ran, they chased her, caught her. She stabbed one of the officers with a giant sewing needle. So she went to jail or the hospital. They took her to the hospital. They filled out a petition and left. 10 days later, they get another 911 call. She's out in the front yard in the driveway, smashing plates, half dressed. They go out again, find her standing under a tree in the snow in her bare feet with a light jacket on. They take her back to the hospital, fill out a petition, and leave. And the police chief asked me, so what happened? Well, I checked with the probate court and nothing happened. So I checked with the state. What happened? Well, what happened was she had insurance. And because she had insurance, it was not going to go through CMH, and the hospital was not going to do anything with it, and she was discharged. What happened to her? We don't know. So hospitals as well, they need to apply the new standard to see if a person requires treatment. And then when they're discharging a patient from the hospital before the hearing, that doesn't cause the part of the petition that seeks AOT to be dismissed. They need to understand that. Now, that's happening in St. Clair County, by the way. And then be sure to notify CMH at the deferment conference. If it is deferred, release the person to the CMH. And then finally, if a person is hospitalized on a combined order, then the statute clearly states the patient may not be discharged without prior consultation with the outpatient treatment provider. And I can tell you, this never happens. But if you get the hospitals, the EDs, the community treatment providers, the courts, all in the same room at the same time, they can work through these issues and make sure these things don't happen. So bottom line, it takes the community if we're going to make this mental health system work. Everyone plays a role. Connection and communication are vital if we're going to have one handoff to connect people with treatment. Okay, I see there's who participates in mediation. The mediation that took place included the respondent, the petitioner, the parents, and the treatment team. And it really depends on the particular case, but you'll need the treatment team represented there, as well as the petitioner and the patient. All right, people are often connected to treatment providers, but do not follow through. And since it's voluntary, it stops there. This happens to a large percentage of people seeing ER. I agree. That's why you need the AOT, because the AOT creates as a court order. And we've had relatively few of those in Michigan. We have 800 and growing in Wayne County, 400 and growing in Genesee County. Those are probably the two biggest ones. Let's see. You mentioned advanced directive, mental health power of attorney not being recognized by most hospitals. This results in excluding family. Why does the state not require hospitals to honor? Well, that's a pretty complicated situation. On the national task force, I work with a doctor who's been a real advocate of these things, but no one's been able to figure out a way to make them work. I think they're a good idea, but no one really knows how to make it work. Let's see, Betty Hansen says there are a lot of parties to this proactive process. Where are funds coming from? You know, the Wayne County is doing this. Genesee County is doing this. Genesee County did get a grant from the federal government to support their AOT program, but this program saves money. It saves a lot of money. You think about the hospitalization costs, these reduction of 60 to 70%. Actually, Huron County, the first 10 people they put on AOT had nearly 40 hospitalizations between them. And once they're on AOT, they had 2 hospitalizations between them. So they saved significant expense in terms of hospitalization. If mediation occurs before filing the AOT, who makes up the treatment team? Well, this requires connectivity with the CMH. Now, it depends if it's a petition by a provider, then the provider, in essence, is the treatment team. You may not, if you're a family member filing a petition and you get AOT ahead of time, then there probably will be nobody from the treatment team unless you contact CMH to get them to the table, which would be a good idea. Okay. All right, Northern Michigan getting psychiatrists. All right, so this is a very good point about the shortage of personnel. You may have read today that about 50 of our state psychiatric hospital beds are taken offline due to a lack of staff. They don't have enough people to staff the hospitals, and we don't have enough social workers across the state. And that really is a huge problem. Now, if we rely on telehealth, then we can address those issues of a shortage of persons in various parts of the state. So I would recommend that we use telehealth. And, to the extent that we can take individuals who are we call it friendly faces. Let's take those 600 people in Wayne County who have 36% of all the cases. If instead of having them cycling back and forth through the hospitals, the emergency departments, and the courts, we can get them into treatment and keep them in treatment, frees up resources for everybody else. It's not a silver bullet. It will not solve all the problems, but it will solve a lot of problems. And I can tell you that at least in Genesee and Wayne County, there are about 1,200 people who are in treatment today that would not have been in treatment but for the changes in the law. So court hearings tend to be open and public record, helps to protect people's personal health information. Well, it doesn't really. The courts don't really protect that sort of thing. That's why I do suggest a change in the statute so that instead of filing the treatment plan with the court, you simply file a notice with the court that the treatment plan is on file. Relatively few cases have to go back to the court for compliance issues, maybe 5%. The trouble is we've got 100% of the treatment plans. And we don't need that, and we shouldn't have those things. So let's see. We see a lot of ERs discharging folks almost immediately if the client has substances on board, even though I know a huge portion of folks have co-occurring disorders. You know, this is a very good point, and that's why you need that stakeholder meeting. That's why I need the hospital at the table to address this problem. And if you get the hospitals and the emergency departments, because not always the same thing, but you need them at the table. You need the sheriff, the jail, law enforcement, courts. Everyone needs to be at the table and work through these problems. And it works. Genesee County is probably the best example because they've been doing it the longest. And they have these stakeholder meetings. They're not every month anymore, but they have them, I think, every other month, and they identify problems. And which is why you have to have families in this too. You know, the kinds of questions I'm getting here that really relate to the performance of the system. Well, those are family members. And if they're not as part of your stakeholder group, then it's not going to work. There is no fee structure in this program. The treatment that is rendered, you know, it's paid for by, I believe Medicaid pays most of this. So
I
that's it.
do, Judge Mack.
All right.
Let's say, so we know that our jails, you know, the jail population is probably close to 40% individuals that need mental health treatment. So let's say the corrections officers witness an individual picking hairs up off of the jail floor. They start drinking their urine and maybe even more unusual behaviors. Would it make sense for then the corrections captain or sergeant to file an order requesting treatment? And if they know this person has been part of the revolving door and that outpatient treatment isn't working, that they would specifically request inpatient. And also now our jail, I think, has both a part-time medical doctor and part-time psychiatrist. So could they, within the jail, initiate the order, have both the MD and the psychiatrist prepare clinical certificates based on their assessments, and then file that with the court requesting inpatient care, or maybe a combination? How would that work?
I'm not sure the jail will give up the prisoner. I can tell you that in Wayne County, they file petitions for assisted outpatient treatment, and the person is actually receiving medication in the jail based on the outpatient treatment order. But in order to get into the hospital, you still have to have clearance, first a screening from CMH to approve it, and then you have to have the 2 certs. But typically, in that situation, I think you need to once again have the jail partner with the hospitals and be present at the stakeholder conference. You might want to take a look at what's happened in Miami-Dade. Judge Stephen Leifman, when he took over as the, he was the public defender in Miami-Dade, and he went and visited the jail, and the conditions were beyond squalid. And so he scheduled a meeting with all the stakeholders, and nobody showed up. And then sometime after that, he got appointed as a judge. He sent out the same letter, everybody showed up. That's that convening power that we have. So everybody was there at the table, and you're welcome to, there's some great videos of the experience up there, but the bottom line, by the time they got done, they had closed the jail. saving $12 million a year. They provided CIT training to 6,500 officers and 911 operators in Miami-Dade. People with mental illness weren't getting shot by the police anymore. Law enforcement was not being injured in fights because they were talking to people and calming them down. So the fact that they did so well on that the workers' comp premium went down. And they've done that, and they're not a Medicaid expansion state. So they've done a lot with a little. And I think we can follow that. And we actually had Judge Leifman up in Wayne County to participate with us in the sequential intercept modeling process, which have you done the sequential intercept modeling in Grant Traverse yet?
Yes.
Yeah, that's important, but it takes a community.
It
You gotta
does.
have all the voices at the table.
And I think our jail would gladly give up some of their individuals because they're in there for, the petty things that are
Right.
typical, just trespassing and that sort of thing. So even though they had a psychiatrist and a medical doctor prepare the clinical certs, they still, because if this is a Medicaid individual, they still need CMH to give the green light for inpatient care.
Well, it
Or they
depends
take before they send the order to the court.
if CMH is going to be the payor, yes. If
Yeah.
not, no. Wayne County, when the pandemic was underway, 51% of the inmates in the jail had a case history with the CMH in Wayne County. 51%, and which is disturbing. Now, I will say this: we have through the Diversion Council, we have a bill introduced. I think it's 6399 that would divert misdemeanors from the forensic system into AOT. And it would also change who testifies for AOTs. So an AOT could be testimony could be a psychiatrist or a psychologist or a medical doctor or a clinical nurse practitioner or a physician assistant under the supervision of a psychiatrist. We need to broaden the people who can testify on the need for services, because ultimately the psychiatrist has the power to terminate at the end anyway. So this is the upfront part. If there's need for treatment, and you don't need a psychiatrist to determine if someone actually needs treatment. People in the treatment community can do this. So I would add that we are working with the Center for Behavioral Health and Justice in Wayne State University, and they're developing an AOT toolkit, which is available online, and it's under development. And I would suggest you might want to take a look at that. It's a great resource. They're doing great work. So let's see, we just had an overly long hospital situation where the hospital refused to communicate with family or the CMH treatment team. That's why you have to have the hospital at the table, so that sort of thing doesn't happen. What advice would you give a parent who's requesting long-term residential care, Charles in Harbor Oaks? This one, I'm confused about the need for a psychiatrist. You don't need a cert, you need a psychiatrist. Yes, if you file a petition for AOT only, no cert is required. The reason certs are required ordinarily is because you're holding someone in a hospital involuntarily pending a hearing. So in order to do that, the law requires that you have 2 certs in order for that to happen. However, on an AOT only petition, the person stays in the community. They're not hospitalized. And so you don't need a cert in order to initiate the petition. The purpose of the cert under the traditional pathway is to keep the person in the hospital, the basis for hospitalization pending a hearing. So the statute currently says you have to have a psychiatrist testify if it's AOT only, unless the psychiatrist signs a petition and then a doctor could testify, or the person can waive. That's how it plays out. But we're going to see if we can change the statute and broaden who can testify. All right, looks like Mary Ann, you can answer this question.
Yeah, I just wrote in the chat that if someone wants specialized residential treatment for an adult with more severe mental health condition and they're a Medicaid beneficiary, they would have to go through the community mental health as or like the placing agency unless there's an ability to pay privately.
Yeah, so the important takeaways here are that we don't have to wait for crisis anymore to intervene to get someone treatment for their mental illness. We don't have to wait for crisis. We don't have to wait until they're a danger to themselves or others. We need to make a decision. Do they have a mental illness? Do they understand their need for treatment? Are they willing to accept treatment? If not, is there treatment that would work, that would help? And if they're refusing treatment that's necessary to keep them well, then the question is, are they headed for disaster? Is there a risk of harm in the future? And the law, the science is pretty clear that untreated mental illness has all kinds of bad side effects down the road. So this really is focused on the fact that someone has a mental illness, they're refusing treatment, they don't understand the need for treatment, and this inevitably leads to harm. So that gets us into treatment. And it's the immediacy of the threat that governs whether it should be in the hospital or on an outpatient basis. And that's my first point. And the second is the hospitals play a huge role here, as do the emergency departments. They need to recognize and apply the right standard. And if there's a deferment conference, they need to follow the law. And when it comes to discharges and release, they need to follow the law. We can make great progress if we just do that. I think of all those people in that revolving door that keep coming and going, and they aren't connected to treatment. We need to start there. So I think the fact that we now also can have assisted outpatient treatment without hospitalization is a huge advantage. And we can substantially reduce the amount of hospitalization that we need. So communities got to work together. They all have to understand their respective roles and how their activities impact other activities. So, Kate?
Could you speak briefly, Judge Mack, I think we have time, about how to extend an AOT and for how long, how many extensions can a person get, please?
First of all, there's no limitation on the number of extensions. The way to do it is, at least 14 days prior to expiration of the AOT, you need to file a petition. Now, the petition is filed by the team, the treatment team, the AOT team. They file the petition, and they need one cert by a psychiatrist. And then the case goes to trial. You don't have to have a psychiatrist testify. And any medical professional can testify to the extension. And when we amended the statute in 2018, let's say a Services Bureau did a typographical error, and so that the second order is for 90 days. It was supposed to be 180. And then the order after that is for up to 1 year. So, but there's no limit to how many extensions you can get. This question, if someone defers, is that the same as an AOT? It's like an AOT. An AOT is actually a court order. If they defer, there is no court order. When someone defers, it means the hearing is adjourned without date for up to 180 days. And if during that period of time the person is non-compliant, then they can be a hearing conducted or they can be picked up. But the deferment is supposed to identify what is the treatment plan that the person's agreeing to. That way you know if they're non-compliant. If you don't identify what the treatment plan is in the deferral, then it doesn't do any good. But a deferral is, you might call it an AOT light, because it's in essence the same kind of thing in the sense that it's an agreement to outpatient treatment as prescribed by the doctor, but it's not enforceable by court order yet. So similar. And there's an identified shortage of psychiatrists. That is a huge problem. But if we can begin to get people into treatment and into recovery, we can reduce our reliance on those services. And those services can be spread around better. But we also need to think about how do we need to use psychiatrists all the time for all these petitions? And I would suggest we do not need to use a psychiatrist in the way we do. We're using the very highest end of care to make these assessments about going forward, when it's the psychiatrist who supervises all of this anyway, oversees it all anyway. So it is an area that we can fix. It will take changes in the statute. So I can tell you that in Genesee County, when they have people who are non-compliant, they will have them transported to the emergency department and then try to convince the person to accept their injectable medication. And sometimes they do, and sometimes they don't. But what they'll tell them at the hospital is that we may have to hospitalize you if you don't take this injectable, although or we can do the injection and you can just go home. And usually that works with an injection. If it doesn't work, then they really have to wait until they need to be hospitalized, because the enforcement power of the court for an AOT is pretty limited. The court can have the person picked up and transported to a crisis unit to be evaluated and assessed for purposes of hospitalization. But if they don't meet the criteria for hospitalization, which is not the same as the criteria for treatment. Criteria for hospitalization focuses on how immediate the harm is. So if the harm is not sufficiently immediate, you won't get hospitalization. You'll still be on AOT. AOT is a tool and it works. We have data from around the country on it now, and we've seen arrests down by over 80%. And we've seen hospital stays dropping in some parts of the country by 75%. Hospital stays are shorter, patient satisfaction is higher. So it is definitely an improvement over what we have, because what we have does not work well. So I thank you for inviting me, and you asked great questions.
Wow.
I hope I answered them adequately.
You have, Judge Mack, a lot of important and potentially life-saving information that you've given us. Thank you so much. Thank you for sharing your time and your wisdom with us today. And thank you for leaving your contact information at the end of the slideshow. And everyone will get a copy of this webinar. And so watch your mailbox. And thank you everyone who attended today, and that you care about understanding what the current standards are for treatment, and that we might all be able to come together better going forward to plan some of these things out so that we have a more effective treatment system. So I guess that's it, and have a wonderful day. Thank you.
Thanks, everybody.
All right.